in New York. Yasmine has over 20 years of experience in international arbitration and litigation. She's been with Mattiaccio since 2009. Initially trained in Paris and admitted in New York, Yasmine is experienced in civil and common law systems. Yasmine has represented clients in arbitration proceedings under all leading institutions rules, as well as in ad hoc arbitrations. She's acted as presiding, sole co-arbitrator, emergency, and consolidation arbitrator in ICC, AAA ICDR, SCC, LCIA arbitrations, and others. We also have today Richard Mattiaccio. She's a chartered arbitrator, an independent arbitrator and mediator here in New York. For more than 35 years, Richard has served as an arbitrator in scores of business contract disputes and has broad experience in mediation, both as counsel and as a mediator. Richard has served as tribunal chair, sole arbitrator, and tribunal member in connection with a broad range of international and domestic, commercial, intellectual property, and executive employment. Mediation, he's effectively represented clients in obtaining settlements and has successfully mediated disputes between many parties in long-term commercial relationships. Richard's focus is on neutral work and domestic and international commercial, IP, and executive employment disputes under AAA ICDR, CPR, ICC, UNCITRAL rules, and others. All right, so Yasmine's going to start us off with a seminar on good faith and estoppel in international arbitration, quo vadis. Richard's going to follow that up with practice tips on persuading arbitrators and on using the UNIDROIT principles. So with that, the floor is yours.
Thanks, Elizabeth. Good afternoon, everyone here on screen. Thanks for having me. It's nice to see everyone. I'm very happy to be here today. I think very impressed by what you're doing. I think it's very exhilarating to go through these practice rounds, but it's also a lot of work that shows to add to your schedule as law students. So congratulations, well done, and best of luck on those practice rounds and the actual round. An interesting aspect of the Moot problem that caught my attention was the respondent's challenge of the validity of the arbitration agreement. While it did not sit well that a respondent would raise such a challenge 2 years after having signed the contract and even after it renegotiated that arbitration agreement, it is also true that such an objection is based on mandatory rules that were in the Constitution, which is likely in implementing an important state policy, and the claimant was fully aware that the arbitration agreement had to be ratified by the Parliament, and that such ratification had not happened. This raised the question of consistency, good or bad faith, and questioned whether claimant could really not see that objection coming. Bad faith disputes is a difficult and complex tool to grapple with, as it has so many forms. And it is hard to apprehend because its existence is very much in the eye of the beholder. At some point, when you are so entrenched in advocating your client's position, you not only disagree with your opponent, but you start questioning their motives and their good faith. So this problem prompted me to remember a seminal article that had been written in 1985 by the late Professor Emmanuel Gaillard, who had foreseen the emergence of Estoppel, which he defined as the prohibition against self-contradiction or inconsistency to the detriment of another. He saw it as emerging as a general principle of the lex mercatoria, that is the law among merchants. His article had been prompted in part by the 1983 arbitral decision in AMCO versus Indonesia, in which the tribunal, who had been asked to apply the principle of estoppel, had made an important pronouncement that this is a principle of general law. Any convention, including conventions to arbitrate, should be construed in good faith. That is to say, by taking into account the consequences of their commitments of the parties may be considered as having reasonably and legitimately envisaged. In this short presentation, I hope to attempt to delineate the accepted definitions of estoppel in international arbitration and in domestic systems, and study how that concept has been applied by arbitral tribunals to examine and then question the limits of that doctrine, especially when dealing with jurisdictional issues. Estoppel defined. Estoppel is a flexible doctrine in terms of scope and relief, which was developed to prevent inconsistent conduct to the detriment of another, irrespective of the truth of the underlying situation. It is close to other concepts such as waiver, acquiescence, or recognition, but it is different. In the other three are unilateral acts. Recognition is the explicit and acquiescence is the implicit recognition of an obligation. And waiver is a person's consent to give up a right that actually existed. But estoppel is, as Cambridge professor James Crawford said, precisely not a unilateral act. It is a representation, the truth of which the entity on whose behalf it is made is precluded from denying in certain circumstances. The most characteristic element of estoppel is not the conduct of a party or other, but rather the confidence that is created in the other party. And here lies the crux of the distinctive feature of estoppel, where recognition, acquiescence, and waiver create or abrogate an obligation or relinquish a right. Estoppel does not change legal status, but is a much harsher and radical tool, as it precludes the assertion of a fact that would provide the basis of a legal claim. In other words, it prevents the assertion of a fact that might be true. To achieve it, it operates as a mechanism of inadmissibility. It is a prohibition made against someone who made a representation to then assert and prove a fact that is inconsistent with the original presentation. As you know, estoppel is a concept derived from the common law and developed by the common law's equity courts. And one definition that was offered by Spencer, Barr, and Turner in their third edition in 1977 was that when one person, the representer, has made a representation to another person, the representee, in words or by acts or conduct, or being under the duty to represent, to speak or act by silence or inaction, with the intention, actual or presumptive, and with the result of inducing the representee on the faith of such representation to alter his position to his detriment, the representer in any litigation which may afterwards take place between him and the representee is stopped as against the representee from making or attempting to establish by evidence any averment substantially at variance with his former representation, if the representee at the proper time and in the proper manner objects thereto. This is a procedural device. And this is echoed in New York law. The doctrine of estoppel requires three elements on the part of the party estopped: conduct, which is calculated to convey the impression that the facts are otherwise than those which the party subsequently attempts to assert; intent that such conduct or representation will be acted upon; and knowledge, actual or constructive, of the actual fact. And on the part of the party asserting estoppel, they need to know lack of knowledge of the true facts, good faith reliance, and a change of position on the basis of the representation. In public international law, the first known reference to the estoppel was in the ICJ decision, in their opinion, by Vice President Alfare in the case concerning the so-called Temple or Preah Vihear, which was a case between Cambodia and Thailand in 1962. And it was said, in international law, one may find, again, as an example, a definition which similarly combines the elements of prejudice to one party and advantage to the other in order for the substance of estoppel, whatever the term employed, to describe the same. The state must not be permitted to benefit by its own inconsistency to the prejudice of another state. In that case, which was about the location of the Thailand-Cambodia border, Thailand was disputing the delineation of that border based on a map that had been made pursuant to a treaty between France, before Cambodia became independent, and Siam, to whom Thailand succeeded in 1908. And the ICDR ruled that even if there were any doubt about Siam's acceptance of the map in 1908, Thailand is now precluded by its prior conduct from asserting that it had not accepted a map deriving from a treaty which it benefited from during 50 years. France, and through France's intermediary Cambodia, had relied on that acceptance. Thailand cannot today, although while continuing to benefit from the resolution, dispute it was ever a party to that resolution. After that, the ICJ developed a jurisprudence that consistently applied the strict view of estoppel with the two key components, representation and reliance, detrimental reliance on that representation. And you probably know the sea continental shelf, where there was a dispute between Germany on one side and Denmark and the Netherlands on the other concerning the border, the delimitation of the continental shelf, which was adjacent to all these countries. The Netherlands and Denmark argued that Germany was stopped from denouncing the terms of the 1958 Geneva Convention on the continental shelf, since Germany had participated in the drafting of the convention and subsequently acted in accordance with its provisions, even though it had never ratified. And the ICJ disagreed with the Netherlands and Denmark and said, having regard to these considerations of principle, it appears to the court that only the existence of a situation of estoppel could suffice to lend substance to this contention. That is to say, if the Federal Republic were not precluded from denying the applicability of the conventional regime by reason of past conduct, declaration, etc., which do not clearly and consistently evince acceptance of that regime, but also had caused Denmark or the Netherlands, in reliance of such conduct, detrimentally to change their position or suffer some prejudice. Of this, there is no evidence whatever in the present case. And on that basis, in 1958, Professor Bowett summarized the notion of estoppel in public international law. The statement must be clear. The statement of fact must be clear and ambiguous. The statement must be made voluntarily, unconditionally, and authorized, and there must be reliance in good faith on the statement, either to the detriment of the party relying on the statement or to the advantage of the party making the statement. This is the so-called strict view of estoppel, and we will see there is a broader definition which in effect dispenses with the requirement of detrimental reliance and really operate as a prohibition against self-contradiction. Now moving on to the lex mercatoria, moving a little bit away from public international law. I come to the late Professor Gaillard's article in which he saw estoppel emerging as a general principles of law in commerce. And his analysis started with the 1983 ICSID decision on jurisdiction in the AMCO versus Indonesia, in which Professor Goldman and Rubin and Feugl demonstrated the tribunal's general inclination to recognize the applicability of the doctrine of estoppel, even though in that case, they did not apply it. In that dispute, there was the foreign party, AMCO, and its local subsidiary, PT AMCO, had invested in a hotel in Indonesia, along with another foreign investor called Pan American. And then they started the arbitration against Indonesia, alleging that the hotel had been wrongfully seized by military action, and that Indonesia had wrongfully revoked the investment license. Indonesia claimed that the arbitral tribunal lacked jurisdiction to rule on the lease dispute that had been concluded between the local subsidiary and the owner of the building where the hotel was, PT Wisma, on the basis that PT Wisma was not a contracting state. And to preempt a potential argument of alter ego argument by the claimants, Indonesia argued that the claimants were stopped from invoking an alter ego relationship between the state and PT Wisma because PT AMCO, the local investor subsidiary, had taken a contrary position before the domestic Indonesian courts. This proved irrelevant because the tribunal found that it has jurisdiction not because it was a lease dispute, but because it was a claim for compensation for wrongful taking under the relevant treaty. But nonetheless, the tribunal analyzed the estoppel, and after going through the historic common law definition that we just mentioned, they adopted the three elements that we talked about, and then they took the detour to specify, even though they had decided that estoppel was not applicable, then they said, although this dictum refers to activities of states, the tribunal is of the view that the same general principle is applicable in international economic relations where private parties are involved. In addition, the tribunal considers that, in particular for its applications in international relations, the whole concept is characterized by the requirement of good faith. So when the tribunal of that caliber, including Professor Goldman, makes such pronouncement, Estoppel had a newfound footing as a self-standing and autonomous rule applicable in international arbitration. Now, how have arbitral tribunals applied that concept? A German academic, his name is Andreas Kollig, conducted a systematic review survey in 2016 of how investor state tribunals had applied that concept. And his findings were as illuminating as they were disappointing. Conforming the view that estoppel had become a general principle of law, public international arbitration, he found 46 decisions discussing the matter of estoppel, including 36 discussing it at the level of jurisdiction and the rest on the merits. And speaking on numbers, the estoppel argument was rejected in 33 instances and upheld in only 9 cases, with the rest not addressed. Looking at the substance of the decision, a small majority of the decision adopted the strict view, including the detrimental reliance point, followed with a close second with a broad view, and the rest is sort of left unclear. And what was most interesting and compelling is that in every instance in which the tribunal expressly adopted the narrow, stricter view, they inevitably rejected the estoppel claim. And half of the decisions the decision that actually upheld estoppel adopted the looser, broader view. And I invite you to look at that decision, at that article, because he makes a pretty thorough analysis of the relevant awards. One you probably know is the UCOS decision, in which the claimants had invoked the tribunal's jurisdiction on the basis that Russia had provisionally accepted the Energy Charter Treaty. And they said that Russia was stopped from raising any objection because of its so-called long-standing and unqualified support for the provisional application of the ECT during the negotiations. This was a pretty radical position because it was a shift from the typical pattern of representation of fact to here in effect an allegation of or representation of law. Ultimately, the tribunal disagreed and found that Russia had given no clear and unambiguous representation that it would apply provisionally the ECT. They found basis for jurisdiction elsewhere, but not based on the argument of estoppel. Another interesting example in international arbitration of estoppel is in the Chevron against Ecuador decision. That's a long running saga which had started in the 1990s in connection with the pollution of the so-called Lago Agrio field in Ecuador. A lot of oil had been found there. Oil had been pumped, and including by Texaco, an affiliate which became an affiliate of Chevron. And in '93, some local residents started a class action lawsuit in the Southern District of New York against Texaco to force Texaco to basically clean up the area and provide compensation for the inhabitants that had been affected by the oil contamination. And Texaco asked and succeeded in having the case dismissed on forum non-convenience ground. And doing so, they alleged that the courts in Ecuador were fair and competent to deal with the problem. This is a perfect case of be careful what you wish for, because as you know, the case went to the Ecuadorian courts and resulted in a dramatic decision ordering Chevron to pay $20 billion to the plaintiffs. That award was never paid. Instead, Chevron started a BIT against Ecuador for violation of the bilateral investment treaty and denial of justice, and prevailed. And Ecuador had an interesting estoppel argument. They said, since you told the Southern District of New York that our courts were fair and competent, 20 years ago, you cannot come to this tribunal and claim that our courts are in fact not fair and not competent to deal with this problem. Obviously, that was rejected because the facts had changed in the meantime. But you'll see how the many ways and creative ways in which advocates have been using and or abusing this concept. Mr. Kuluk looked at how tribunals adopted the broad or less strict view, which, as I said, does away with the requirement of detrimental reliance. And that made its appearance, this broader view, in the early 2000s. You can see it, for example, in the Middle East Cement versus Egypt, Fraport v. Philippines, Desert Line projects against Yemen, and so forth, and so on. And the takeaway of Mr. Kulik's analysis is that when the tribunals adopt a strict view of estoppel and seek to apply the test rigorously, they do so to deny the claim of estoppel, whereas in many cases where they accepted the claim of estoppel, they did so on the basis of wobbly, he thought, legal foundation and tended to sanction inconsistent conduct irrespective of the other party's reliance. And his concern was that the arbitral tribunals who upheld estoppel never really took the time to explain why they abandoned the ICJ's jurisprudence, which does clearly require both elements. Interestingly, the estoppel has been adopted in domestic systems, of course, the United States, as you know, even in the context of arbitration, where it has been used to bind non-signatories to arbitration, or to allow non-signatories to force signatories to an arbitration agreement to arbitrate against them. And that was discussed in the General Electric decision of the Supreme Court in 2020, where they said that the doctrine of promissory estoppel was compatible with the written requirement of Article 2 of the Convention. That concept has also been used in Switzerland, which is more focused on the prohibition against self-contradiction rather than the other components. In France, it's interesting because it achieves the same result through the so-called appearance, the apparent agency doctrine. And it's basically the civil code said an act made by a representative without authority or beyond his authority cannot be set up against the person whom he represents unless the third party with whom he contracts legitimately believed that he had that person's authority, notably by reason of the latter's behavior or statements. But fast forward, and in 2010, the French Supreme Court actually explicitly adopted the concept of estoppel and did so in the context of an ICC arbitration. And it was in a case where the respondent had brought a late counterclaim. And as you know, under the ICC rules, you have to be allowed by the tribunal to bring a late claim. And they have to be found to be within the scope of the terms of reference, which are signed at the beginning of the case. And while the claimant objected to the admissibility of the counterclaim, the tribunal found that it was admissible and issued a provisional order allowing the counterclaims to proceed. And after the tribunal issued its final award, in which it upheld part of the respondent's counterclaim, the claimant sought to vacate the award in France. And the Court of Appeals had said that the claimant was stopped from doing so because the claimant had failed to object to the procedural order allowing the counterclaim. And the highest court, the French Court of Cassation, reversed that decision because they said the claimant's procedural conduct did not constitute a change in its position in law such that it deceived the other party on the claimant's true position. And therefore, it did not amount to estoppel. And in that case, the French equivalent of the Solicitor General had argued that estoppel requires a contradiction in the procedural conduct that manifests itself as a change in position and the intent to deceive the other side's legitimate expectations based on the original position and a forced change of the other side's argument based on that change. Now, I will leave you to think about what is the proper regime of estoppel and think about why is the broader, looser view potentially problematic. And as we discussed, Estoppel is a doctrine that ought to be used sparingly because, as is said, like a magic trick, Estoppel prevents the assertion of what in fact might in fact be true. This is a tool of quasi-fiction. And besides the fundamental question of whether investment law produced by ad hoc tribunals should strive to be harmonious and consistent, the question then is whether the law should sanction any contradictory statements, irrespective of their relevance or significance. Or as Professor Gaia asked in his 1985 article, should contradiction per se be systematically prohibited? And his answer was no. He said it would indeed be particularly dangerous that any contradiction should be sanctioned as estoppel, and shocking that a party could invoke the contradiction to its own benefit, even though that party suffered no detriment. In other words, the application of the principle simply requires not only a contradiction, but a contradiction that effectively harmed another. I will leave you with this thought, and also to what extent a tribunal should be allowed, how far tribunal should go in assessing its own legal jurisdiction based on a principle of estoppel. And a good example is when you're dealing with sort of Article 25 of the Exit Convention, which requires not only consent, but is based on the true objective nationality as a condition of the state's consent, and also the legality or the illegality of the investment. In that case, is it sufficient to see to prevent the tribunal to raise that the problem of the nationality based on some inconsistent conduct they had in the past? Of course, if the state has issued a license recognizing that an investment was valid or had a certain nationality, that this is evidentiary support that the investment was in fact legal. But if it was in fact illegal, is it acceptable as a matter of public international law to brush that under the rug simply because of the state's inconsistent conduct? I don't have an answer, and I will leave you with that question. I think now Richard is going to speak to you about the much more interesting topic of
now for something completely different. Thank you, Yasmine. That's a very important topic and a developing one in international arbitration. But what I'm going to talk about today, first I want to thank the ICDR for organizing this pre-moot every year. It's my impartial opinion, it's one of the best. And I think you're all showing tremendous progress as I've seen different teams and different competitions. It's great to see input being put into action by the students as they go forward. So in the parlance of the VIS, I have two submissions. The first is tips on advocacy, specifically before arbitrators. My first observation is definitely not limited to arbitration, but it's important. Know your audience. Most courts are generalists. Most arbitrators tend to be more sophisticated in what they're doing. It's one of the reasons why arbitration is chosen, but they're not super specialized, and they're not going to be as knowledgeable about your problem as you are. So in the real world, you get an opportunity to choose your arbitrators. In this world, you do not. But you can, and should, as advocates, play the odds. In New York City, you're going to see mostly experienced commercial arbitrators. In Vienna, you're going to see more of a mix. You're going to see more civil law tradition. You're going to see more academics than you would see in New York at the Moots. I can't really address the VIS since I haven't gotten a chance to go in the East. The common characteristics of all commercial arbitrators, and I'm only going to talk about when you're dealing with commercial arbitrators because that's my experience, is they live and die by the agreement. Right? They exist only because of the agreement. They look first and foremost to the language of the agreement, and language of the agreement to arbitrate if the issue is question of arbitration, and then to the container agreement on the merits. Other arguments tend to be less compelling on their face. Public policy, no one elected or appointed arbitrators to be the keepers of the public good. They exist to resolve discrete contractual disputes for the most part. State actors tend to emphasize public policy. To all but the most specialized investor state arbitrators, I think this often public policy questions tend to sound like a diversion from the language of the contract, right? The language doesn't help, so you're talking about something else, right? If you have a decent argument based on the language and structure of the contract, emphasize that as much as possible. Keep bringing the discussion back to what the contract says. For example, on the misrepresentation question you're all dealing with. How and where is the term state-of-the-art used in the purchase and supply agreement? Right? If you want to advocate an expansive view, you're going to focus on state-of-the-art in the whereas clause, right? Modifying aircrafts and talk about state-of-the-art and newest model as if they were interchangeable terms. If you want a more limited view to be taken by the arbitrators, you will draw their attention to Article 2, seller's obligations in the PSA, where newest model modifies Kestrel I 2010 UAS, not UAS, where state-of-the-art modifies geological surveillance feature, not UAS. So focus on the contract, look for where it helps you, focus on that. Don't be afraid, my second point is don't be afraid to argue in the alternative. Your position may be at the outset that the agreement is void. Your alternative argument can be that if the tribunal is inclined to look at the agreement as an indication of the intent of the parties and then go from there. The bottom line is if you are arguing before commercial arbitrators, arguments based on the language and structure of the governing agreement is going to catch the arbitrator's attention much more than other arguments because that's what they're comfortable with. The next point is prioritize your arguments to coincide with what you think your audience's priorities would be. The logical order is not always the most effective order presentation. You lead with your stronger arguments and you end on a strong note. And somewhere in between, you deal with all of those troublesome issues. But you lead with strength, you end with strength. Am I right? Don't lose credibility by leading with a weak argument, because you may not get your credibility back. That's especially true when you're dealing with the facts. There may be a geographic component in order your arguments. In New York, as I mentioned, you're dealing with commercial arbitrators for the most part. Arbitrators in New York are sensitized to questions regarding limits to their jurisdiction. Less so in terms of experience in dealing with official corruption. It's just not so familiar to arbitrators in the United States, unless you happen to get arbitrators who are experienced in dealing with other markets where official corruption is dealt with in arbitration. And that's not to say that there isn't official corruption in public contracts in the United States. It just doesn't end up in arbitration, it ends up in court. So again, the basic premise is know your audience, appeal to your audience. Along those lines also, try to trade places mentally with the arbitrators. Vet each argument as a team with the question, how is this argument going to play to these arbitrators once you know where you are, basically. I understand that you may not know very much about your arbitrators going in, but you need to try. You have to present a strong but fair argument on the presentation of the facts, especially. You will lose credibility very quickly with arbitrators if you play fast and loose with the facts. If you only emphasize what helps you, you have to take on what doesn't help and give it a reasonable interpretation that either defangs it or actually does help. Refer to the record. I see many of you referring the arbitrators to the record. This takes time and it can be a little cumbersome. So refer to the arbitrators to the record sparingly when it really matters, and then give them the time to get there. Right? So start with the page reference in the record before you start describing what it is, because then as you're describing what it is, they're turning to the page. Right? If you do it the other way around, then they're scrambling to find it at the end, and you may lose them. Devote most of your speaking time to the strengths of your case. Don't become too defensive. Don't be reactive to the other side's argument. You have to anticipate the other side's argument, yes, but you need to present the storyline, the narrative that is yours, and incorporate the other side's arguments into that story. You need to know the other side's storyline as well as the other side knows it. And of course, that's assisted in the moot with the fact that you're arguing both sides of the issue. You need to identify the obstacles to winning, and you need to work your response into your positive narrative. If the other side fails to make an argument that you're concerned about, don't rely too much on that omission. It will be somewhere in the papers. If you think it might sway the arbitrators, deal with it, or you may be unpleasantly surprised because the tribunal can see an argument that neither side addressed. Arbitrators are not supposed to introduce new law, new facts, obviously, but they can and often will connect the dots if you don't do it for them. So you may be unpleasantly surprised if you ignore an argument that you're concerned about, just because the other side hasn't done too well with it. Avoid characterizing your own arguments. Right? If you make statements like something is clearly so, that's almost a challenge to the arbitrators to find where it's not clearly so. It suggests that you may not be all that confident in your argument. And don't compliment the arbitrators on a question. Please don't do that. If you respond to a question by saying, that's a very good question. The response may be, thank you very much, that's why I asked it. Now would you like to answer it? Avoid jargon. Above all, avoid talking too much like a lawyer. It's not going to impress. You must use plain English if you're operating in English. It is more likely to convey a sense of candor if you use simple language, and the sense that your argument is common sense. This is probably counterintuitive because you're spending a lot of time commanding or gaining a command, mastering legal jargon, but try as much as possible to be plain spoken. In oral argument, you must listen to the question and read it. If it's coming from an arbitrator, it's important. Even if it's a dumb question, you have to deal with it, and deal with it diplomatically at the very least. Don't try to shift the conversation back to your theme until you've done your best to answer the question. It can be annoying to some arbitrators, if not all. If at oral argument, when counsel responds to a question simply by continuing with the prepared outline, as if the question had never been asked. Arbitrators don't like that any more than judges. If an arbitrator suggests an argument that you have not made, but that could help you, at least without an arbitrator, don't reject it out of hand. This has happened to me in this past week. This comes under the rubric of don't bite the hand that's trying to feed you. It does not mean you have to agree with the argument if you know it's wrong. It does mean you have to be diplomatic. Sample response. Mr. Arbitrator, I had not considered this argument, but it appears to be another way to get to the position I am advocating. As opposed to, no, you're wrong. Under such and such a case, you're just wrong. You don't want to do it. Sample situation, an arbitrator sees language in the PCA that she thinks helps you. You have not argued the point because you're taking the pure position that the argument is void, so you're not going to rely on the language of the contract. You're an advocate, as I said before, you can argue in the alternative. The PSA were not void, this language would support your position. Right? Try to use it affirmatively, or at least don't offend the arbitrator. That's all I have in terms of general tips, and I'm sure you've heard much of this before. But sometimes it's good to review. For my second proposition, I'm going to talk to you about specifically about UNIDROIT principles and how to use them or not use them. We're all being primed to use the UNIDROIT principles. It's in the problem. I should say, since many of you may only know the principles by seeing them online as black letter principles, there is also a published version which you can get in your library, which has commentary and illustrations. And you can find a lot more there than is in the black letter law. You should try to dig that out of your library, the 2010 principles, not the current 2016 principles, but if all you can find is the 2016 principles, that's fine. There's a table of correspondence at the beginning, which will tell you what provisions were in the 2010 principles. Someone on your team should read through the principles. There may be some helpful, it does attempt to be a comprehensive statement of commercial law. And so you will find arguments in there. You will find useful language if you take the time to go through it. But you also need to be aware that there's some controversy among the academics over whether or how to use the principles as such. The principles as such, as a statement of international commercial law. And some arbitrators you will encounter, I think especially in Vienna more than in New York, will be aware of that controversy. If you launch into an argument by simply citing the principles, you may well prompt a question from an arbitrator. Counsel, we have an agreement that provides that the law of Equatoriana governs. Why should we look to soft law like the UNIDROIT principles? You could wait for that question, or you could, and if you do wait for the question, you're not prepared. The answer is procedural order number 2, paragraph 49, which is at page 49 of the record, conveniently. The relevant provisions of the contract law are in all 3 countries identical to the UNIDROIT principles 2010. The way I read that is that the UNIDROIT principles are the law of Equatoriana. If you're citing to them, you're citing to the national law of Equatoriana. It may be useful to remind the arbitrators of that when you're talking about it. Under the law of Equatoriana, which is identical to article such and such of the UNIDROIT principles, 2010, right? And then read from the principle. Don't just launch into the principles because you may step unexpectedly into this controversy over how the principles can be used. So if you're arguing that it was respondent's burden to obtain parliamentary approval, the respondent can't use its failure to do so to avoid the purchase and supply agreement. I'd argue, under the law of Equatoriana, which is identical to the UNIDROIT principles, article 6.1.14, it was respondent's responsibility to obtain parliamentary approval and go from there in your argument, rather than just jump into the UNIDROIT principles. There are many ways to use the principles, and some of them are quite controversial. The UPIC, another acronym for the UNIDROIT principles, preamble sets forth several ways in which they can be used. 2 are worthy of mention. both because they're controversial and because you might step into them unwittingly when you're using them and trigger this controversy. One is that the principles may be used to interpret or supplement international uniform law standards. The CISG, if it applies, is an international uniform law instrument. So you could find yourself making that argument. And the other is the principles may be used to interpret or supplement domestic law. Both are controversial. You may encounter arbitrators in Vienna or at the Moot East who hold the view that it is not appropriate to use the principles as a gap filler for the CISG unless you first show that that specific article you're referring to reflects an international consensus or general principles of law. Some arbitrators hold the view that you should look for CISG gap fillers first in the national law or in general principles of law. And that if you think the principles are a good statement of general principles, you have to persuade the arbitrator. Our problem allows you to avoid all of this if you use the right approach. Principles are a statement of the national contract law of Equatoriana. Paragraph 49 of PO2. So you argue them as the law of Equatoriana and you avoid all of these issues. The potential use of the principles to help with applying domestic national law in the international context. The concept here is that national law is designed for national problems. And international trade results in situations that the national law may not have anticipated. So you can look to the principles when you're applying the law of, let's say, the law of New York to an international contract. It's also unnecessary to do that here. Because if CISG applies, it's because it's embedded in the national contract law of Equatoriana. And the principles apply because they are part of the national law of Equatoriana. So you're entirely within the realm of national law when you're using these two. Now, you may or may not prevail on the argument as to whether CISG applies or is excluded because of the definition of aircraft. But if it applies, it's because it's national law. And if the principles apply, it's because they are national. So the bottom line is the safe approach to using the principles is to cite the relevant article, the principles, as the national contract law of Equatoriana. It's that simple. You've made it simple in the problem. Don't find yourself in the middle of a controversy because of the way in which you've introduced the principle. With that, I will stop. And again, good luck to everyone. You're all doing very well, and I think we will continue to improve with each session and do very well in Vienna or in the East if you go. Thank you.